Get ready for the dictation. Start. Further, the writ petition is completely silent about the election return of polling booth numbers 180 and 181 having been received by the petitioner or her Nirvachan Abhikarta and Ganna Abhikarta. The copy of the election returns in Form 47 as per the guidebook along with the counting sheet in Form 43 dated 3/5/2021 of the polling booth numbers 180 and 181 placed before us along with the written instructions so the description/details of the votes as is required to be noted under Rule 53 of the Rules 1994. The total number of the votes received by each candidate have been mentioned therein. The petitioner herein also does not dispute the details or the number of votes indicated in the memo dated 6/5/2021, subject matter of challenge in the present writ petition. For the aforesaid, in the facts and circumstances of the case, we find that the mistake in the computation of the votes of two polling booths was an arithmetical/clerical mistake. The said mistake, when brought to the notice of the returning officer on 4/5/2021, on the very next day when the certificate of the elected candidate was issued to the petitioner on 3/5/2021, he, as a vigilant officer, after scrutinizing the record of his office, when found the mistake being minor/formal in nature, proceeded to erase the same at the earliest by issuance of the notice to the petitioner. It is demonstrated before us that in the process of correction the petitioner did not participate. From a threadbare discussion on the issues raised before us in the light of the legal position and the procedure of the declaration of the election results under Rule 1994 and the instructions issued by the State Election Commission, we find that the action of the returning officer in making correction of such an error by only tallying the votes already shown in the election return of Form 47 prepared under Rule 53 cannot be said to be hit on the plea of lack of jurisdiction. Rather, the re-inspection of the records by the returning officer was needed to maintain the sanctity and stability in the election process. There was no reason as to why a candidate who had received highest number of votes be asked to approach the election tribunal when the mistake could be corrected by the machinery which was operational at the relevant point of time. We may reiterate that the elections were not denotified by then and even the final result had not been declared on the portal created by the State Election Commission for the purpose. There is one more aspect of the matter, that while exercising equitable discretionary jurisdiction under Article 226 of the Constitution of India, we must keep in mind that substantial justice is done in the matter and the High Court would not issue a writ which would revive any illegality. The quashing of the certificate issued in favor of the opposite party number 7 would result in cancellation of the election of a candidate having attained highest number of votes. We see no reason to upset the election result and relegate the candidate having highest number of votes to approach the election tribunal for removal of a minor defect. Moreover, before partying with the judgment, we deem it fit to express our concern on the number of litigations flowed to this court post declaration of the result of member Kshetra Panchayat. In the month of May and June 2021, soon after the elections of member Kshetra Panchayat were concluded, this court has been flooded with the writ petitions during the peak of second wave of pandemic COVID-19. Most of the writ petitions were raising the issue of the cancellation of the certificates or issuance of the subsequent certificates to the elected candidates by the returning officers. In almost all of the cases before us, the mistake was found to be clerical or arithmetical. The candidates whose certificates had been cancelled had vehemently pressed that the returning officers lacked jurisdiction to issue another certificate by cancellation of the previous certificate. Such a situation, according to us, arose on account of the language of the Rules 54 and 56 of the Rules 1994, which give room for doubt. In the 1994 rules, there is no provision for issuance of a certificate nor any form for the certificate to be issued to the winning candidate had been prescribed therein. Stop.